Thank you, everyone, for joining us today. My name is Morganne Foley. I am a partner and immigration lawyer at McInnes Cooper, based in St. John, and my colleague, Renee Thompson, is also an immigration lawyer. You should see both of us on the screen there. So we're here today to talk about immigration target reductions and also key strategies for you to continue to access foreign workers. Many of you probably have heard in the news and in recent reports of changes to the target numbers or overall allocations, if you will, for temporary foreign workers and for newcomers in general to Canada. As anyone who has been sort of following immigration will have seen, we really saw a post-pandemic boom in terms of numbers of foreign workers and numbers of newcomers, really in response, especially to low unemployment rates, record high job vacancies, and in 2022 in particular, as a post-pandemic measure, we saw expansions of the numbers of foreign workers and new policies and things that were in place. We're seeing now a shift in the other direction where the labor market really is changing. We have declining job vacancies, and so the government has put in place some changes to their targets and their forecasting, particularly over the next 3 years, in response to those challenges, to reduce the number of temporary foreign workers in some cases, and to put plans in place to level off some of those numbers that in the recent past have been increasing year over year. So today we just want to talk about what that actually means. You know, we're hearing reductions, but what is being reduced? What do those changes mean for you, for your business? And what strategies can you use to try to continue to access foreign workers? Because certainly the need for job vacancies, the need to fill those positions has not gone away for many employers. And just to get us started and to get a little sense of who we have on the webinar here, we want to start with just a quick polling question. So it asks, do you currently rely on temporary foreign workers? You'll have 3 options: yes, no, or not yet, but you want to. So I'll just give a minute for folks on the line to put their answers in, and we can see what kind of response we receive. If you haven't yet, you should see the answers. So we have quite a mixture across the board here, really. 33% saying yes, we do currently hire temporary foreign workers, 20% no, and 47, so almost half of our group, not yet, but wanting to. So I'm happy to see that kind of mixture in terms of answers, because hopefully we will provide tips for everyone across the board here today. Just to set the stage a little bit and elaborate on what I was just talking about as far as these reductions and these targets. If we look at the next slide, you'll see here that currently our population as of 2023 is made up 6.2% of temporary residents, with the remainder there in red being our Canadian population, meaning permanent residents and Canadian citizens. And so what the Minister of Immigration has announced as of March of this year is that they intend to, over the course of the next 3 years, reduce that to 5% of the population. So, you know, a relatively small decrease, but you'll see over the course of this presentation how it impacts various pathways and what it will mean for our overall population in Canada. And if we look just to the next slide, we break that down a little bit further to say, you know, who are we talking about when we talk about temporary residents? So if currently 6.2% of our population And over the course of the next 3 years, 5% of our population will be made up of temporary residents. Who exactly are we talking about? So it's really an umbrella term that covers a large number of streams. And if we look here, you can see that 42% of temporary residents in Canada are international students. 9% are actually temporary foreign workers under the temporary foreign worker program. And we're going to get into this in a lot more detail, but when we talk about the temporary foreign worker program and workers who fall under that category, we're really talking about LMIA supported work permit holders, compared to 44% who are temporary workers under the international mobility program. So those are LMIA exempt work permit holders, which is really another umbrella term when we think that LMIA exemptions, there are numerous, and that number, that 44%, is comprised of postgraduate work permit holders, spouses of students and spouses of skilled workers, so spouses who are on open spousal work permits while their spouse is working or studying in Canada, partially made up of reciprocal youth exchange programs. Some of you may be familiar with the International Experience class, which is a class of work permit that allows for youth exchanges. And others are new arrivals who have come through special humanitarian pathways. A good example of that would be the QET work permit holders, the Ukrainian public policy that was in place to give open work permits. So, a large mixture of LMIA exempt work permits who fall under that 44% of International Mobility Program, or IMP, work permit holders. And then 5% of temporary residents are asylum seekers who are waiting for their claim to be heard at the Immigration and Refugee Board, and they are open work permit holders, so they have the ability to work while they're waiting for that claim to be heard. So if we think about the key program policy changes, this is really what we're going to go over in our next couple of slides, the key changes that have been announced. So we'll dig into each one of these, but just an overview, we are talking about a decreased percentage cap of temporary foreign worker programs, so again, LMIA holders, under the low wage stream. We're talking about expanded LMIA recruitment criteria. So anyone who has made an LMIA application in the past would be familiar with the need to demonstrate that you have recruited for the role and attempted to hire a Canadian citizen or permanent resident. We're seeing a decreased duration of LMIA validity, or really rather a return to pre-pandemic levels when it comes to duration of LMIA validity. And we're also seeing net zero study permit growth in terms of goals over the targets in the recent announcement, as well as stabilized permanent residency admissions. So we're going to get into all of those. I will be talking specifically on the LMIA pieces at the beginning, and then Renee is going to talk about study permit numbers and stabilized permanent residency. So again, just before we talk about specifically what those mean, we have another quick polling question to say, are you concerned that these recent announcements and policy changes will impact your business? Again, 3 answers that you should see popping up on the screen. Yes, no, or not yet. So maybe you're not concerned just yet, but you are waiting to see what our next slides have in store. We'll just give another minute again for you to make your selection, and then we'll see what we have across the board there. All right, so the majority of folks on the line are concerned. Makes sense. We're glad that you joined us here today so that you can learn a bit more about, whether or not you should be concerned and what those concerns might mean for your business. So let's dive right into some of those key policy changes that I was just summarizing. So if we think about the LMIA and the LMIA cap in particular, we'll see, again, really a return to pre-pandemic numbers as far as the cap is concerned. For anyone who may not be familiar with the cap, the LMIA program under the low wage stream, so there's a high wage stream and a low wage stream. Under the low wage stream, there is a percentage cap on the number of foreign workers that you can employ who are low wage LMIA supported work permit holders. So we saw an increase for some of the key sectors that were outlined in a workforce solutions roadmap, and we'll get to that on a future slide here in terms of what specific sectors we're talking about. We saw an increase in 2022 in response to the high unemployment rates for this cap from 20% to 30% of the workforce, meaning 30% of your workforce could be comprised of low-wage LMIA supported work permit holders. We're now seeing a return with a couple of limited exceptions to 20% of the workforce. So again, you want to be conscious of the number of individuals that you're employing who are on those low-wage LMIA supported work permits and what percentage of your workforce that they make up. What exactly are we talking about when we talk low-wage or high-wage LMIAs? If we just look at our next slide here, you'll see a little bit of a summary to give you a sense. Essentially, there's a median wage for each Canadian province and territory. If you are paying a wage that is an hourly wage at or above that median, then that's considered high wage LMIA. The cap does not apply to the high wage LMIA. So key distinction with what we're talking about here. The cap applies when you have a low wage LMIA, so below that median wage. We just have a couple of small examples across the provinces there. You'll note on the far right, New Brunswick at $24.04. So a wage of $24.04 an hour or higher is a high wage. Anything lower is low. Similarly, in the Atlantic provinces, Nova Scotia at $24 an hour. PEI is $24 an hour. Newfoundland and Labrador, $26 an hour. And then you can see, Ontario there and Northwest Territories. So every province and territory has their level, and that will determine whether or not your job position that you're getting the LMIA for is a low wage or high wage category and whether the cap applies. And then you'll recall that I mentioned this is really with respect to particular sectors. So what we're seeing in terms of this decrease from 30% to 20% are in the food manufacturing sector, wood product manufacturing, furniture and related product manufacturing, accommodation and food services. And the exceptions, or those that are still going to maintain that increase 30%, are the construction industry, hospitals, and nursing and residential care facilities. So those low-wage healthcare positions will not be affected, and construction positions. And so, what does this mean? What is the impact practically for employers who are looking to use LMIAs to fill some of their low-wage positions? So if we just jump to the next slide there, it may mean that you have to look at adjusting hiring practices and perhaps relying more on domestic labor market. Those who have previously relied on that higher percentage of 30% are going to have to adjust practices in order to comply with that reduction to 20% of the workforce. And it may also mean that you are, like I mentioned, relying more potentially on domestic labor markets, or maybe on alternate pathways in terms of, finding open work permit holders, for example, under the IMP. Maybe it is, if you're just on that cusp between low and high wage, maybe it's increasing the wage for a particular position in order to be considered a high wage LMIA. So you have to really take a look at the workforce that you have and the positions you're hiring for and see how you can adjust in response to this change. As has always been the case when applying for the LMIA, employers will be required to demonstrate compliance with the cap, and ESDC will not issue a new LMIA if it's going to put you above that minimum cap. And employers will also have to look at their transition planning. So many times LMIAs are issued if the position is a permanent full-time position. It's issued in support of a foreign worker for whom you wish to support their PR application, and that is kind of part of the goal of the temporary foreign worker program, is to gradually transition temporary residents into permanent residents. So it might also mean looking at your workforce and seeing who you're able to support for permanent residency in order to transition them so they are not counted as one of your work permit holders for the CAP anymore. And has always been the case, compliance and inspection is always very much an important thing for employers to understand when it comes to LMIA. So there are strict employer compliance requirements, and these changes to the CAP really are no different in terms of making sure that you are in fact complying with the CAP and with all of your other obligations as an employer using the LMIA streams. We noted as well expanded LMIA recruitment criteria. And if we just take sort of a step back and think about the work permit process, if you will, we have just a small diagram on the next slide to show that, how a person obtains their work permit, whether that is an LMIA supported work permit or not. An individual requires either a visa if they're from a visa requiring country, or an ETA if they're from a visa exempt country, plus their work permit in order to then be authorized to work in Canada. And so, like I mentioned, that may be a work permit that comes under the LMIA program, or it may be a work permit under the LMIA exempt program. So we'll just skip ahead probably 2 slides if we can to our work permit slide. Just the next one, please. Okay. So when we're talking about these recruitment requirements, so again, anyone who has made an LMIA application in the past would be familiar with the need to canvass the Canadian labor market. As part of your application, you have to demonstrate proof of where you posted your ads. There are very strict advertising requirements as far as the content of those ads and where they are posted. And historically, we have been required to report on the number of qualified Canadian citizens or permanent residents who have applied for the position, or really rather the lack thereof. So it's the inability to find those qualified Canadian candidates that would qualify an employer to obtain an LMIA. Now the Canadian government is looking for employers really to explore every option for hiring before obtaining the LMIA. And specifically what they have described is a need to also canvass the labor market for those asylum seekers who make up that 5% of our temporary resident population, as you might recall, who have those valid open work permits, in order to ensure that you're also offering positions and recruiting for asylum seekers with open work permits before you're making an LMIA application. And so again, what does this mean for you? What is the impact of this recruitment criteria? Potentially, it may mean that it's a little harder or more work involved to obtain the LMIA, right? A little bit more burden on employers in terms of demonstrating your recruitment efforts. And it may mean a requirement to reduce reliance on the temporary foreign worker program. So again, if you are successful in recruiting an asylum seeker who has an open work permit, then your ability to employ them with that work permit would reduce your need to make the application for the LMIA. And then finally, before I hand it over to Renee, I just want to talk about the decreased LMIA validity duration and what exactly that means. And I think our next slide has the best summary of what we have seen in the recent history in terms of LMIA duration. So this is specifically referring to how long the LMIA is valid once it has been issued by the SDC. And that means how long you as the employer have to identify the foreign worker that you wish to fill that position with, and for the foreign worker to submit their work permit application based on that LMIA. So pre-COVID, it was always a 6-month duration from the date that the LMIA was issued, it was valid for 6 months. So you had to identify that worker and submit their work permit application within the 6 months. We saw an increase to 9 months, and then we saw our biggest increase ever in April of 2022. So again, a lot of these key changes and expansion of the policies happening in 2022, where the numbers doubled to 18 months of validity. So employers had over a year to recruit for positions that were named in that LMIA and for the foreign workers to make their work permit applications. In January of this year, that was brought back down to 1 year, so 12 months. And then now, effective May of 2024, we've come back down by half again to the pre-COVID levels of 6 months. And so, employers who maybe were previously relying on a longer window of time to identify foreign workers are now back to that 6-month window. And if we jump ahead and just talk about the impact, that's really the primary impact, is that shorter time frame in which to use your valid LMIA. And it will probably also mean, adjusting hiring practices potentially because of the shorter duration, meaning your window of time to identify the foreign worker is a lot shorter than it has been in recent years. And so with that, I'm going to hand it over to Renee, and I'll come back at the end.
Okay, thanks so much, Morgan. So I'm actually just going to be talking about some of the policy changes regarding study permit applications. So as you know, earlier this year, IRCC released a policy change regarding study permit applications. In addition, they also set an intake cap on international student permit applications. And the reason for doing this was really just to kind of stabilize new growth for a period of 2 years. So we're just gonna basically just go into a poll question that basically just asks do you hire postgraduate work permit holders, and how would this affect you?
Morgan, you might have to jump on just to share the results.
Sure. So I'm not sure if everyone can see, but we have almost 50%, 47% who say yes, they do hire postgrad work permit holders, 33% of no, and 20% no, but are interested. So again, quite a spread there. And when Renee describes the recent changes, you'll see, how that might affect your business for those who are existing users of postgrad work permit programs, and what you may want to consider if you're thinking about using or hiring postgrad work permit holders.
Okay, so as you can see here with the target, so IRCC earlier this year, they set the target, 2024 target at 485,000 approved study permits. But as you can see, gradually the number gets reduced, and that's really just because in addition to how much they set their initial target for this year, they also had to take into account certain factors. So for example, if you look at the number that says 97,000, that accounts for international students that are already in Canada and are looking to extend their stay in Canada as students. And then you'll also see a number 12,000. That's just a buffer amount that IRCC will kind of take into consideration for other variations. And then you'll see the number here at 140,000. This pretty much accounts for the students that are kind of exempted from this intake cap. So in other words, the students that are exempted would be primary students, secondary students, are students that are obtaining like a master's degree or a doctoral degree in Canada. So as you can see, taking into account all of these factors and the numbers, the initial target that they set at 485 kind of gets reduced to 236,000. And then if you kind of convert that to the cap, you're looking at about 393,000 study permit applications. In terms of like the impact, as I mentioned before, there are certain international students that are exempted from the cap. And in addition to that, those who aren't impacted are those who are also like on current study permit holders within Canada, and those who are also looking to like renew or extend their stay. Now, I would probably say like in terms of like the biggest impact would probably be the amount of international graduates that are going to be like issued a postgraduate work permit. So by the Minister of Immigration pretty much putting like a cap on the amount of international students studying in Canada, as you can see, overall, that would have an impact on the number of international graduates who would be eligible to apply for a postgraduate work permit upon graduation. Now, in a case like that, what they would have to do really is they would now have to kind of navigate like other options to obtain a work permit within Canada so that they can still work in Canada upon graduation in case where they wouldn't be eligible to obtain a postgraduate work permit. I would also note that this would also impact spouses for these individuals who are affected by the impact. So I mentioned like certain individuals that were exempted, but those who would be like impacted would be like international students who are studying and obtaining like an undergraduate degree or that are obtaining like a college diploma. So the spouses of those individuals who would usually apply for an open work permit would now have to look at other options to obtain a work permit within Canada. So they would have to look at other solutions and other categories for obtaining work permit. Now, in terms of policy changes in stabilizing PR admissions, we know that last year, IRCC did implement a 2024 to 2026 immigration levels plan as a way to kind of support economic growth while balancing with the pressures in areas like housing, healthcare, and infrastructure. And as you can see here, these are just some of the targets that they were looking at between 2029 to present and even to 2026 in terms of their levels plan. And in terms of like the impact, we know that with them stabilizing PR admissions, one of the biggest, I guess, impacts in this area would be that there would be a lot of competition for applicants trying to obtain PR and navigating PR pathways. So for example, we know like with express entry and the different economic immigration programs that fall under that stream, like the Federal Skilled Workers Program, the Federal Skilled Trades Program, and the Canadian Experience Class Program, that there's been like a lot of changes in terms of like selection like categories, and also like for CRS like score thresholds being a bit higher, making it a little bit more competitive for applicants that are wanting to apply for PR under that stream or that PR pathway. And I guess in terms of like options or what they would have to do, would be like ways to kind of increase or better their chances of obtaining PR under those pathway streams. So maybe like, improving their language score, or maybe pursuing like higher education, or maybe navigating another PR pathway option. For example, maybe going the route of applying under provincial nominee programs. But oftentimes they would look to their employers to kind of see like what existing PR pathways would align with their job offer that they have with that specific employer, and how they would be able to obtain PR during for that pathway. And then I also wanted to just kind of talk about like strategies that are available to continue accessing foreign workers for employers that are within Canada. So as you know, Morganne spoke earlier about like LMIA work permit options for employers that want to hire foreign nationals and how they would have to obtain LMIAs and the impact that has. So what I'm going to just talk about briefly are just different LMI exempt options that are available to foreign nationals that want to come to Canada and work, and which employers can hire these foreign nationals under this type of option. So one of the LMI exempt options is under global skills strategy, and you have like the global talent stream, which offers like an LMI exempt option for certain highly skilled workers. And basically, this is pretty much a way for like employers to kind of hire and access global talent efficiently from foreign nationals in certain countries. And then another option would pretty much be like regional and provincial programs. So for example, you have like provincial nominee programs. So as you know, like if a foreign national, whether in Canada or outside of Canada, is nominated under a specific province or territory for permanent residency, they would often be issued a nomination certificate. And if they aren't currently working within Canada or outside of Canada, they would then have to request for a work permit support letter. So this actually would be included with the work permit application when they're applying for it. So instead of using the LMIA in support with the work permit application, they would then use the work permit support letter that was issued by the province, include that with their work permit application, and then be able to apply for the work permit. And then with like rural and northern immigration pilot program, again, this is like another LMI exemption option that's offered to foreign nationals who have like a valid job offer from an employer in one of like the participating like rural or northern communities, and who have received like a recommendation from like a designated communities economic development organization. So again, with under this type of program, again, it's an LMI exempt option that has specific criteria for both the employer and the foreign national in terms of what would be required in applying for like a work permit for that foreign national. And lastly, you have like the Atlantic Immigration Program. Again, this is another LMIA exemption option that is allows like pretty much employers in like Canada's Atlantic provinces, so Newfoundland and Labrador, Nova Scotia, New Brunswick, and Prince Edward Island, pretty much like allows these employers that are within these specific provinces to kind of hire foreign nationals without needing an LMIA. And it's pretty much in like a way to kind of address the labor shortage needs within those specific provinces, and also promoting economic growth. So again, this type of program pretty much, you know, there's like certain eligibility criteria, again, with the employer and the foreign national. For example, with the employer, they would have to be designated within that specific province. And then once they are, and it's at the time where, you know, you're applying for the endorsement certificate that you would use in support of the permanent residency application, again, if the foreign national is not working in Canada or is outside of Canada, they would request that they need like a work permit support letter from that specific province or territory, which we would then include with the endorsement application. And then the foreign national would then be able to apply for the work permit using that work permit support letter. And then they would also follow the different steps that are needed in order to successfully submit the application. For example, submitting the LMI exempt online offer of employment that's done through the employer portal, including the LMI exemption code in the application, and so forth. So again, these are just some of the LMI exempt options that a foreign national can use, and the employer can also use when looking to hire foreign national to work for them in Canada. So I'm going to have Morgan continue talking about other types of LMI exemptions that are available to foreign nationals that are looking to work in Canada.
Thank you, Renee. So yes, so I think you know, the main thing to think about this is if we go back to at the beginning when we had our little pie chart showing, who falls under that umbrella of temporary residents, right? 9% are those temporary foreign workers under the temporary foreign worker program, or again, the LMIA supported pathways. 44% are workers under the various international mobility program streams. And so an important takeaway today is that the changes are not with respect to these IMP or LMIA exempt work permits. They remain available to you as employers and probably will become, if they aren't already, a really key part of how you continue to access temporary foreign workers. So we've got a number of categories listed on the slide here as some additional examples. Some of you may be familiar from having used these programs before. Entrepreneurs and self-employed individuals, so there are IMP work permits available under that category. Emergency repair personnel and repair of out-of-warranty equipment. Those are categories that are frequently used in cases where there's really a temporary and urgent need, sometimes in response to a true emergency, sometimes in response to more of a planned shutdown when it comes to out-of-warranty equipment. But an individual who's a foreign national who's needed to come in, not because they have a permanent full-time offer of employment from an employer in Canada, but because they have the necessary skills and perhaps they're employed with the foreign company that is responsible for selling and producing the particular equipment, for example. And they are needed to come and use those skills to conduct repairs on, again, an urgent basis or in response to out-of-warranty work when there's no one else in Canada who can complete those repairs and updates. And so that's a frequently used IMP work permit option as well. There are some for TV and film essential production workers. So again, that would really be a shorter duration project where someone in the TV or film industry is required in Canada. There are IMP work permits for charitable and religious work, so depending on the nature of the employment. There's also Francophone mobility work permits, which are intended for French-speaking individuals who are going to be working outside of Quebec across Canada. And we've really seen as well, we haven't gotten into it in today's presentation, but an increase in general in the Francophone targets and a desire to increase our Francophone population in Canada. So again, as far as strategies that you might be using as an employer, looking to potentially to French-speaking individuals who are eligible for the Francophone mobility work permit, or who maybe are getting additional points under express entry and have a higher chance of having their permanent residency application proceed under that program. These are all potential strategies that you may want to look at if you aren't already. And the Canadian interest work permit, or the significant benefit work permits that are available to employers. So these are, again, LMIA exempt work permits for cases where there is such a significant benefit, it may be an economic, social, or cultural benefit to Canada to have this individual come and work here, that it outweighs the usual requirement to obtain an LMIA. And so, those are very case-specific scenarios, but these are all things that we would explore, for example, as your immigration lawyers, to determine whether these are options that are available to you if you find that you are struggling based on these changes to the LMIA programs, or even based on the reductions of postgraduate work permit holders that Renee described, and the impact that has on the overall hiring market. So just to expand a little bit on that, if we look at the IMP work permit options, again, another one that is frequently used are work permits that fall under free trade agreements. And there are numerous free trade agreements between Canada and other countries. Some of the most commonly used examples appear on your slide there. The USMCA, which is the former NAFTA agreement, so US, Mexico, and Canada, Canada-Peru, GATS, which is encompasses a large number of countries around the world, CETA, which is in the European countries, and the CUKTA or CUKTA agreements, which is the UK version, used to fall under CETA, and now they have their own. And so these are all varieties of free trade agreements that have options for work permits for citizens of those countries who are coming to work in Canada. And, you know, a few of the examples that you see across the screen there are professionals. So, for example, under USMCA, there's a list of professionals. Engineers is one example. Individuals who have a Bachelor of Engineering degree and a job offer from an employer in Canada will be eligible to make a work permit application that is exempt from the LMIA. Intercompany transferees, so that ICT that you see under a number of the agreements there, which we'll get into in a little bit more detail on another slide. There are also provisions for contractual service suppliers and independent professionals. So again, a self-employed individual who might be coming to work for an employer in Canada. Open work permits, we touched on them a fair bit in our discussions here today. So the postgraduate work permit is a form of open work permit that's given to eligible graduates after they complete an eligible program of study in Canada. They will still exist, but you know, by nature of reducing or leveling off the number of study permit holders, the effect of that, as Renee described, will be an impact on the number of postgrad work permits that are issued. There are bridging open work permits. So those are open work permits that are available to some permanent resident applicants while their PR application is still in process, and they need a new work permit in order to bridge that gap between the expiry of their current permit and the approval of their permanent residency application. Family members of foreign workers, so again, skilled workers who are here and they have their spouse looking to join them in Canada. The spouse may be eligible for an open work permit, which would allow them to work for any employer in Canada. So when we talk about open versus closed or employer specific are those work permits that name the employer on them, as opposed to an open work permit, which is not restricted to one particular employer. And then IEC, International Experience Class, I had noted in one of my earlier slides as well. That's a reciprocal program where Canada has agreements with a number of countries where there are specific criteria. So, you know, being a citizen of a country, sometimes being resident as well, and not just holding citizenship of that country. Typically being under the age of 35, although it does depend on the country, individuals may be eligible for a working holiday or a professional work permit that would allow them to come and work with an employer in Canada on an open work permit. And then, as I mentioned, when we were talking free trade agreements, the intercompany transferees is one option as well. So for any employers on the line who maybe are multinational in that they have a parent or a subsidiary or a branch of their company that is located in a country outside of Canada, there are options available for employees of the company outside of Canada to be transferred to the Canadian office in cases where they are either in an executive or senior managerial role or a specialized knowledge capacity. So a position that is not necessarily managerial, but is someone who has a very unique skill set, not only unique within the labor market in general, but unique within the company. And therefore, the company needs them to be transferred in to Canada, sometimes for a short duration, sometimes for longer, depending on the project, in order to take advantage of those skills and add to the Canadian workforce. And so those are, again, scenarios where you might be making an offer to have someone temporarily transferred in to fill a labor market gap that you can't otherwise find in the Canadian labor market. And so just before we open it up for some questions, again, you know, if we kind of think of our takeaways as far as strategies, you know, one strategy as well may be for employers who are not already doing this or aren't doing it across the board, is supporting that transition to permanent residency. So I talked about it a bit when I talked about the LMIAs and transitioning to PR in order to reduce the number of work permit holders who are counted as part of your cap. But also in general, I think what we're going to see, and I think what we're seeing already, is things getting more and more competitive as far as the labor market is concerned, particularly if we take postgraduate work permit holders, for example, who are looking to employers to help support them with their obtaining their permanent residency in Canada. For many, that is their ultimate goal, is to gain qualifying work experience on their open postgrad work permit in order to then transition to permanent residency. And given the likely competition that will be in the market with fewer postgrad work permit holders, for example, I think we're going to see more and more that they're seeking that support from employers. And when we talk about the pathways to permanent residency, Renee touched on this a bit with the AIP, Atlantic Immigration Program, the PNP, the Provincial Nominee Program. We do see differing levels of employer requirements and employer involvement, as far as AIP, for example, being the most employer driven. The employer has to be designated under the program. They have to agree to a settlement plan that reflects the needs of the temporary foreign worker in Canada. PNP is still employer supported in most cases, but a little bit less burdensome on employers in that there's no designation requirement. The settlement plan doesn't form part of the PNP, compared with something like express entry, for example, where a job offer may help someone qualify for express entry, but is not mandatory, unlike under the AIP and PNP. It's not mandatory that an individual have that employer support to apply for PR under express entry, but it is a requirement that they have skilled work experience that they've gained in Canada. So I think with that, we'll open it up for questions. We've left, just about 10 minutes for questions, if anyone has any. And I think they'll send them to us just in the chat. So we'll just give a minute for any questions to come in and try to address those. We did have a couple that came as well in advance of the presentation. So I'll just take a look at those. One person raised the issue of navigating pressure from staff to support PR applications while working within the government limitations. So, that's always a bit of a delicate balance in terms of what you're going to decide to do in terms of the policies internally as far as how you're supporting permanent residency. But I do think employers want to take a look at what they are doing and what their employees may be eligible for as across the available programs. So the AIP and PNP, and or even support for express entry, for example, to see who they could be supporting. And then you just see. Someone says, I understand the self-employed option no longer exists. Can you respond? So there are certainly limitations when it comes to self-employed work in Canada. There is a very narrow work permit that still exists for self-employed work. But, in general, what we're talking about here today are those employer-supported pathways anyway. And so those would be not for self-employment. We touched on it as well with the free trade agreements, for example. So under CETA and CUPTA, for example, the European Union and the UK free trade agreements, there are work permits in place for independent professionals. So that would be someone who is coming based on an independent agreement. So they're not necessarily going to be employed by the Canadian entity, but they're coming to work for a 1-year period with an option of a 1-year renewal as effectively as a self-employed individual under that agreement. Yeah, great question here. One of our concerns for non-LMIA routes is processing times. Have we heard complaints about the processing times, and are there tips for minimizing processing times of work permits to be approved? So processing times is always a hot topic in terms of, we always want them to be faster. They're never fast enough. IRCC is always announcing that they are making efforts to reduce processing times. And they have very recently, just as of last Friday, also promised to reduce the inside Canada processing times, in particular in response to they're no longer allowing flag polling for post-grad work permit issuance. So you'll see, if you're familiar at all with flag polling, it was an option to go to the border and have your work permit issued at the border. They've indicated that they will no longer issue any post-grad work permits at the border. And so what they have promised instead is decreasing those inside Canada processing times. The good thing about the post-grad work permit for any of you, and I think we were at about 40% who indicated that you do use them, you'll be familiar with the fact that once a student makes their application for the post-grad work permit, they're eligible to start working full-time. And so that is kind of key to Canada's position on, you're eligible to start work. And so whether or not you have the work permit in hand is not necessary. Therefore, no need to go to the border and get that work permit on day one, because you can start working as soon as you apply online. Now, that's not a perfect system. People need proof of their work permit for a variety of reasons. People may need to travel, but that's sort of the Canadian perspective on that. So, we definitely are seeing still very lengthy processing times for work permits from outside of Canada. And for anyone who may not be aware, the processing time of a work permit is determined by the country of residence where the applicant is residing. So you can search online for the average processing time for a particular country. There are, for those who are visa exempt, the majority of the time they are eligible to apply for their work permit at the port of entry, whether it's an LMIA supported work permit or an IMP work permit. Few exemptions. The AIP is the best example of that. AIP work permits, which are under the IMP program, you cannot make those at a port of entry, even if the individual is visa exempt. So there are always exceptions to every rule. But if you are recruiting from a visa exempt country, that can also reduce your processing time. So that's something to consider when you're looking at your overall timelines for things. Okay, so question about supporting employees for PR, and before they receive their PR card, they're advised not to travel or leave the country. We're not aware of issues. Is there a policy that says you can still travel out of the country on your ECOPR, or your electronic confirmation of permanent residence? Yeah, so good question. The PR landing process, like everything, is, still lots of room for improvement. But what has happened, and again, this is in direct response to COVID, is previously the confirmation of PR, the Cooper document, was issued, and you would have to actually physically go and land. So present that at a border crossing, for example, and complete the landing process. Now, for PR applicants who are inside Canada, that's a virtual landing process. So they get an invitation to confirm their permanent residence online through an online portal. There's a bit of back and forth there in terms of IRCC inviting them to the portal. Then the individual has to confirm they're inside Canada, upload the photo that will be used for their PR card, wait for IRCC to look at that, complete the PR process, and in that same portal, they'll issue the electronic confirmation of PR document. So that is their confirmation of PR. Once the confirmation of PR is issued through that portal, IRCC starts the process on their end of issuing the actual PR card documents. And it has been fluctuating. You know, we were down, I think, as low as maybe 33 days average to have the PR card issued, and then, you know, you got to allow for mailing time for it to arrive in the mail. Then I think we're at 77 days right now. So we're all over the map in terms of averages over the last year as to how long it's taking IRCC to process those initial PR cards. And the PR card is a travel document. So it is a requirement that a permanent resident of Canada who is traveling commercially into Canada, that they use their PR card and their passport from their country of citizenship to enter. So if they're hopping on a flight or if they're taking any commercial travel into Canada. If a person is entering Canada in a personal vehicle, so their vehicle from traveling at a land border, obviously from the US in a personal vehicle, they are permitted to use the confirmation of PR document alone. But they, you know, in other cases, they should be waiting for their PR card in order to travel. And I think we're just about at time there. I don't see another one. So I think with that, we will probably thank everyone for joining us on the webinar today. Hopefully you have something to take back and think about, or you know, if you have any questions following the session here today that you'd like to discuss in more detail, please feel free to reach out to Renee or myself. We're always happy to schedule a meeting, and we could be happy to talk any of those through with you. So thanks again for joining us on your Thursday morning, and take care.